Hey, everybody. Welcome back. We're going live tonight on Facebook from 2 different pages and on YouTube. Yeah, we're using StreamYard tonight, so I'm still learning how to operate it. So you guys be patient with me if I lose you. Anyway, welcome tonight. I hope you guys had a great day. It was a really nice day out, and I was getting kind of cold where I'm at. But that's okay, because we expect that to come. So tonight we're going to talk about a couple of things. Did your lawsuit get dismissed? Did the judge dismiss your lawsuit and tell you that you failed to state a claim? Failure to state a claim under Rule 12B? Well, if that's the case, we're going to help you with that tonight. We're going to show you how to get it done. We're going to do it just like the attorneys do it, and then we're going to stick it back in their face. So we're going to get, but before we get to that, there's a couple other things. Uh-oh. So some Facebook users saying hi, but I can't. So I want to welcome you guys to Advocates for Justice Paralegal Service. And I need to learn a little more. But at least we're getting it done. Okay, I remember how to do it now. We're going to add a banner across the top. Yeah, we're getting fancy now. Welcome to Advocates for Justice Paralegal Service. We are different and we prove it. So tonight we're going to talk about a couple of things. Before we get into that, I want to let you guys know if you send me an email and I answer your email and my answer seems kind of short, it's because I'm trying to get through all of the emails that I have to answer. I'm trying to make sure that I get to your email before I run out of gas. So if I don't put a lot in it, then that's why. And I also want you guys to remember that my job is not to make it easy for you, but to help you learn how to do this. One of the things that I want to tell people is I'm not an attorney. So please don't send me your court documents and stuff. Okay. Now, if you have a question about which document you need to look at, then we can talk about that. But when it comes right down to it, you're going to have to make the decision on the documents you have, because I'm not an attorney and I don't look at any of your court documents. And to be honest with you, I don't open anything that I haven't consented to be sent to me. And the reason I do that is because, there's some haters out there that would like to see me not here. So I make sure that I don't open stuff that I didn't agree to have sent to me, because people's accounts can get hacked. And these fools who do all this kind of stuff, and it took me a long time just to get my website together and to be able to do this stuff. And some of you know I send out links and they don't go anyplace. And yeah, so I'm trying to protect myself to make sure I don't have those problems and protect you guys too. Because if they hack my site and I go down, then I'm really have a hard time reaching you guys and helping you with stuff. So keep that in mind. And please, when you send me an email, keep it short and keep the email pertaining to, pertaining to the question that you have about the lawsuit packages. Now, when you buy a package, now what I've been doing is trying to make sure I have time on the phone to help people explain the package, but I'm going to get away from that because I'm offering the packages at such a low price. It's just hard for me to keep up with all the phone calls, and it's not fair to the people that are already in the program that pay full price. So if you get a lawsuit package and you get a deal on it or you get it on a sale, then you're going to have to get into the group, into our Facebook page to get the support that you need. And you can reach me in the page almost any time. 1 or 2 days a week I'm doing stuff, but most of the time I'm in the page from the afternoon all the way until everybody goes to bed. So you can reach me there. You can also text me too. If you call me and I don't answer, please don't leave a voicemail, because I have so many voicemails at the end of the day, I can't check them until the next day, because I have to write all of them down to get to yours that may be 3 in by the time I get around to even worrying about it. If you call me and you need something, please leave me a text message, a short text message about what it is you need. I have a question about this document. Name the document and let me know what it is. You don't. It's nice if you can put the question in there, because it saves me from having to get on the phone, and I can respond back to you a lot quicker in a text message than I can getting on the phone sometimes. And sometimes I'm in a meeting or I'm in a conference or I'm in a training session. I'm looking at people. They don't know. I mean, they can tell I'm doing something, but I keep them busy with what they need to be learning. And then I can answer you on the phone or whatever. And it's not a problem. I just can't talk. So if I tell you I can't talk, you can text me. Don't think I'm just being a butthead, okay? That's the deal. I can't talk, but I can text. And sometimes you're doing other things that you can't talk on, but you can text. I'm not gonna mention what they are. Anyway, so that's one of the things I wanted to talk about. A couple of other things. When you guys invest in the non-judicial, when you invest in the jurisdictional challenge with an affidavit, you need to make sure that you have reviewed or researched the time frame that the attorneys have to respond. Because what's been going on with that document is people have been filing it and then it just been chilling. And then the time frame for the other parties to answer passes and you're still chilling. Well, when the time frame runs out, you need to be attacking their asses and filing your motion for default and jamming them up. If you don't, then the judge will think you're waiting for him or her to dismiss your shit. And that's what they do. And that's what they've been trying to do. So you need to make sure that you're always aware of how much time the other parties have to answer. And when they don't answer in time because they can't respond to the jurisdictional challenge with an affidavit, think about it. It's a jurisdictional with an affidavit. They can't respond by counter affidavit because what they're doing is fraud. And if the judge dismisses this, if you read the document, you will see that you are demanding the judge to order the other side to prove jurisdiction. It ain't up to the judge to dismiss your case when you're challenging the court's jurisdiction. It ain't up to the judge to prove jurisdiction. It's up to the other party, their attorneys, and they can't. And this document has been killing them. In my opinion, it's the best $200 anybody could spend if they're fighting their foreclosure, trying to defend their property. So when you go into court to defend your property, the two number one mistakes, the number one mistake most people make is they don't have the right party down. They don't, the person that actually initiated the foreclosure against your property is not signed on the complaint anywhere. And most people don't realize it's the attorney. The attorney is the one doing the foreclosure. In judicial foreclosure, the attorney is the one that signs the petition. In a non-judicial foreclosure, the attorney is the one that signs the notice of default letter. And in a non-judicial foreclosure, the whole process is done outside of court until they get to the eviction process. This is why it's so important to get your lawsuit filed. Now, my non-judicial foreclosure defense program has a strategy in it to block the eviction process. Now, I did a lot of homework to figure this out. So, eviction court can only hear immediate possession. So, immediate possession can't. So, eviction court can only hear immediate possession. They can't make a determination on the title dispute. So when you file your lawsuit in federal court, in a higher court, and trump all of their crap, okay, you're also creating that title dispute that you need to control eviction court. And once you file your title dispute, then you take the motion to challenge eviction court's jurisdiction and you stick it in their face. I would file it on the public record if you can, and then file it in court. And that way it's filed, it's already in common law jurisdiction anyway. And then once you do that, you file your challenge to eviction court's jurisdiction in eviction court, and you take a file stamp copy of what you just filed in eviction court, and you add to the notice of removal. Now, notice of removal is not something that the state court gets to rule on. You attach your challenge of jurisdiction to the notice of removal, and you take it down and you file it in federal court in your case. And you tell the clerk that you are removing the eviction case, the immediate possession issue, to be connected to your title dispute. And when they ask you why, you let them know that you've challenged jurisdiction of that court. They don't have jurisdiction. You're connecting their immediate possession issue with your title dispute, because the immediate possession cannot be determined until the title dispute's been settled. And I don't think I've had one case where actually I've had one where they were giving the guy a hard time, but that's kind of because he didn't do anything when they were violating him in state court. And I know those people talk on the phone with each other trying to figure out how to get us under control when we're kicking them in the face. So once you get that connected to your title dispute, the eviction case is done. It's closed. You just removed the eviction case out of eviction court and connected to the title dispute, and there ain't a freaking thing that none of them in state court can do to stop you. You know, it's funny. We have a lot of power, but the fear gets in the way of people stepping up and using that power to take care of what needs to be done. So I don't. So I'm using StreamYard tonight, and I don't see the chat window. So you don't know how I need to get to that. That's one thing that I need to learn. I want to just go ahead and do this so I can start figuring it out. Because if I don't do it, I'm not going to figure it out. And maybe I won't figure it out. Maybe I won't figure it out anyway. No, I'll figure it out. Let me see. Oh, yeah. Okay, here we go. Comments. I got some comments. Hey, guys. Yeah, I'm learning how to do this thing on StreamYard, so it's a little bit different. But the cool thing is I can talk to everybody at the same time, I think, because I'm actually streaming on 2 Facebook pages and on YouTube. So Stephen Johnson, roll call. Stephen Johnson's here. All right, Stephen, and you weren't late. I'm not sure if you're late because I just figured out how to get to the chat window. So if you're late, you won't be running after practice today because you got away with one. You're lucky. So Delaney said, hey, what should Delan Shay said, what should people if they buy a house first? So I'm not sure about your question. What should people if they buy a house first? I think you left. I think you need to elaborate on your question a little more, uh, Dylan. Dylan, can you file this title dispute after the eviction? Yes. So here's the thing. So Gary Lyon asked, can you file a title dispute after the eviction? Absolutely. Here's the thing. If you're in foreclosure court, there's only one thing that you want to be talking about, and that's the court's jurisdiction or the lack thereof. And here's the deal. Jurisdiction can be challenged up to 15 years. And the case law for that is right on the front page of this document. Right on the front page. It can be challenged up to 15 years. The problem that people have when they're challenging jurisdiction and trying to do this stuff is that the judge gets really grumpy and starts yelling at you and act like they're going to try to throw you in jail and all this stuff. And that's all part of their scare tactic. I'll be straight with you because I got no reason to lie. And you know exactly what I'm saying when I say this. I'll tell you right now, if you ain't pissing off the judge, you're getting your ass kicked. Plain. It's simple. If the judge ain't pissed off at you, you're getting your ass kicked. So many people forget that the judge and the attorneys are all on the same team. Everybody in that court up there behind all those tables and taking your stuff and taking your money, they're all on the same team. You're the only one ain't on that team. And the rest of us, we're not on that team. And people forget about this. You know, the conventional program, I don't even waste any time in it at all. I had a lady call me and she wanted me to make some documents for her. I tell her, no, I'm not even going to make the documents for you to file in the conventional program and charge you for them because I know they're not going to help you. And that's what attorneys do. And I don't even want to go there. Okay. And I told her if you wanted to do something that's going to help, you should do one of these things. And I gave her some options, but she didn't want to hear those options. It's really sad. So many people have been indoctrinated to believe such BS, like attorneys have a license. You know, attorneys don't have no freaking license. And that they made you a loan. There's no loan. Cynthia Moore says, hi. Wildcats here. Alpha Taurus is thanking me for my gift and my time and knowledge. Well, you're welcome, Alpha Taurus. I love what I do. And I'm here doing this because of what they did to me. I know what you guys are going through. I've been through it. I've laid in the bed and wondered how we're going to fix this mess and whether or not that knock on the door is going to be the sheriff trying to throw us off the. Yeah, I've been through all of that. And they treated me like I was stupid. And it pissed me off. And, you know, as an athlete, you know, I play football and I box. As an athlete, if you ain't good, you hate to lose. You try to play it off with your kids, you know, like it's not that big a deal, but they know. So that's why I'm here. I hate to lose. So I don't consider I lost, even though I didn't learn all this fast enough to save my shit, but I've been helping a lot of people save their shit. So I feel like I'm winning. So Gary Lyon says he's been evicted, but have not moved out. So Gary, you're not evicted until you're moved out. Okay, because that little crap they do in the eviction court is so ridiculous. They have eviction in that court that can only handle immediate possession. They can only make a determination on immediate possession. So they have it all rigged. So the new buyer comes in waving his new thing that he just got from his buddies over at the county recorder's office or wherever, and that's what they use. That's what they use. And if you know, and the only way that I found to stop the eviction process is to have a title dispute filed in the higher court. And when you do that, you're actually going to be suing the attorney. Because if you check your paperwork, the attorney is the only signature on that paperwork. The lender doesn't sign any of the foreclosure documents because the lender don't have anything to do with it, with the foreclosure. And this is the second mistake that a lot of people think. People get the foreclosure fraud and the mortgage fraud. They think it's one and the same. And it's not. It's not one and the same. They're connected, so to speak. But if you notice, nobody from the foreclosure firm is signing anything to do with the mortgage fraud, and nobody from the bank is signing anything to do with the foreclosure. Have you noticed that? The attorneys foreclosing on your property acting as a third-party debt collector. That's what they're doing. And so in a non-judicial foreclosure, actually in any of the foreclosures, that's a fatal flaw right out of the gate, because they're lying on the paperwork that they filed in court and saying it's the lender coming after you. And they're working on behalf of the lender. But I got people in the Facebook page, okay, that have contacted the lender a whole bunch of times in the same day. And the lender finally yelled at him and told him, we don't have nothing to do with the foreclosures. You need to call the attorneys. And when you serve the lender the service, they send it to the attorneys. And then the attorneys try to answer. The attorneys from the law firm. And see, that's a problem too, because when you add the attorney to your federal lawsuit as the number one defendant, that's a problem. That's a problem because now that attorney, and you add the law firm second and the last servicer, now that attorney has got to take the heat for everybody else that's listed on there that already made money stealing from your property. And that's a problem because you already know attorneys are cowards and they ain't trying to take the heat for everybody else. So you start creating a little bit of a rift. And the bigger problem that the attorneys have when you add their asses to the lawsuit is they have to hire an outside counsel, because the court rules will not allow a corporation to represent itself pro se, because the corporation is considered a fake entity and has to have someone stand and talk for them. So they don't allow people to go into court. So the attorneys are going to have to hire outside attorneys. And that's a little bit of a problem for them, because the outside attorneys, once the outside attorneys learn that you're suing the foreclosure attorney for unlawfully foreclosure against your property, acting as a third-party debt collector, the new attorneys, out the back door. They don't want nothing to do with it. And I'll tell you why. In my opinion, it's because they're doing the same shit. They're doing the same crime, stealing from people. So they can't go in here and go into court when they know you know what the gig is. So now the judge has to allow attorneys to go and represent themselves and the law firm. Oh, now the judge has to violate the rules. Oh, did you just set yourself up for your perfect appeal at the gate? It sounds like you did, because you knew the attorneys were not going to be able to represent themselves, and the judge was going to have to let them go into court. Oh, so check your packet, and you got a document in there to strike the attorney's notice of appearance. And when the attorney's notice of appearance is stricken, all of the stuff that the attorney filed is also stricken. And you're striking the attorney's appearance because the attorney cannot represent himself, nor can the attorney represent the law firm, nor can the attorney litigate a case they're a party to. This is what you call using their own plays against them and sticking them up in their face. And I cleaned it up a little bit with the face. So Gary, if you want to send me an email, I've got a document that you can use to smash that eviction process. I have its sale price at $200. It's the jurisdictional challenge with an affidavit. And so far it has 7 or 8 wins and one not win. Well, let me change that. I don't use the word win, because win means the judge is going to give you a bunch of stuff and say you won. But the document has 7 stops, and it's 7 and 1. And the 1 was because the person didn't follow the steps before we got to that and didn't challenge the judge already in the other situation. And the person did not file a notice of default when the attorneys failed to respond. They just waited for the judge to answer. and that's not what I tell them to do. So this document, it's not posted on my website. So if you're interested in it, you're going to have to send me an email address send me an email to my email address. I had it up here somewhere. I'm just going to post it. Well, yeah, I can send it across the bottom. I can let everybody else see it too. Comments, banners. Okay, send me an email to when in courts. When in courts. 1. There we go. Oops, that's not the right one. Oops. That's my website address. So anybody that wants to get started, you can go there, scroll down to the bottom and check out the questions and answers section. And you can check out some of my videos, and the videos will take you over to my YouTube channel where you can check out even more videos. So, okay, here we go. This one is the one I'm looking for. There you go. That's my when in courts 1 at Gmail. That's my email address. So if Gary, if you're interested in that document, you can send me an email address and just tell me your name and that you talked to me on the live stream tonight, and I'll get that over to you if you're interested in it. Let me see. What should people, if they, can you file this document after eviction? Yep. Our BAM says if you can show the law that firms and associates use to avoid and false document and declare a memorandum would stop the HOA foreclosure. So our BAM, I have a couple of documents to block the HOA foreclosure, and I have a couple of videos on my YouTube site that address that. And I think one of them has HOA in the thumbnail. So it's like it looks like a little house, a magnifying glass over a little house. So you might want to check that out. So Gary said, the lawyer is the only one. Yeah, I know, man. Attorney's the only one on the paperwork, and they're lying. So you can tell when an attorney's lying because their mouth's moving. Okay, that's how you tell when an attorney's lying. So they're lying all the time, trying to say that, oh, I'm not the one on there, and we know it's the lender, and it's not the lender. So you guys know that I have an online course, and I'm going to put the link to that. Here so you guys can go and check it out. Now, this online course is pretty cool. It has upgraded documents that are totally badass in it. And the goal of it is to put together, it's actually in my paralegal school. So I have a paralegal school where I host my online course. And the goal is to put together a program that property owners could use to defend their property if they needed to. Because with everybody, with all this COVID-19 and everybody struggling, you can't get blood out of a turnip or something like that, they used to say. So if your tenants are laid off from work and lost their job because of this mess, then you really can't. Especially if they've been good paying tenants or whatever, you really can't throw money, but you still got to figure out how to protect your property. So I put this package together, and it has this online course together, and it has everything in it that I offer that you could need to help, and it's pretty cool. I'm going to show it right here. Create another banner. There you go. That's the link to my online school, and we have one course in there right now. It's the Judicial Foreclosure Defense DIY Do It Yourself, and I think I have about 11 students in the class. I'm still waiting for somebody to leave me a review, please. Please. Okay, that's a little nicer. So let's go ahead and get on with what we're going to be talking about tonight. Since I've already used up almost the whole time, I still have more to say. Okay, so in most pro se cases, the attorneys will often file a motion to dismiss for failure to state a claim under the federal rules of civil procedure. Now, you guys, when you have questions about when they're supposed to answer or what you're supposed to do or whatever, you should be looking in the federal rules of civil procedure to find the answer that you want, to tell you how long they have to answer, when they're supposed to answer. Now, I know when you look at that, it gets real intimidating because it's a lot of stuff. But I'm going to tell you, just like I tell people who invest in the lawsuit package, open up and find out there's 16 documents. Well, now there's 24 because I added the magistrate judge reconsideration package to both of the lawsuits. So you can sue the judge, file a claim against the judge. You can recuse the judge. All of what you need to do all of that has been added to the lawsuit. So what I tell people is don't worry about the number of documents that you have, because your goal, you can only do one at a time. Okay, one step at a time, one document at a time. So you don't have to worry about all of them. So that's the same with these civil rules procedures. All you need to know is the rules that you need to know right now so that you can get your stuff up in their face and get done with what you do. So Rule 12b-6 is a subpart of the Federal Rules of Civil Procedure, which state in general that all defenses must be put in the defendant's answer. But it also gives the defendant an option to raise some defenses by motion before the answer is filed. Now, this is what we do whenever they serve you. Our thing is we want to answer with your lawsuit in federal court. Now, you don't have to do all that stuff they're having you do. You want to answer with your lawsuit in federal court, challenging the court's jurisdiction. Because remember, jurisdiction can be challenged at any time. After the trial, before the trial, after the judgment, up to 15 years. Attorneys aren't going to tell you this shit because they don't want you to know. They like doing what they're doing. And they need you to be paying them. They need to be getting your money. So that's why, if they told you this shit, it should be over like before they got a few more payments out of your bank account. So Gary, my program will let me. Gary, you can talk about that. We'll talk about that later. You can email me or message me. When you email me, I'll have your email address and I can add you to my group, and then we can talk in the group. I want to get the rest of this presentation done that I promised to give people, because I got people wanting to see it. I want to hear it and see it, I guess. And then we can talk about what you need later. you should go to my YouTube channel, and I have a playlist in my YouTube channel. It's instructional video playlist for the lawsuit packages. And you can click on the judicial or the non-judicial one, whichever one it is that you need. And that playlist reviews all of the well, it doesn't have the magistrate, the reconsideration package for the magistrate judge stuff in it, but it reviews all of the normal documents that came in that package before I added the other 4 or 6 documents that you need to kick the judge's butt. So we can talk about that later. Right now, I just want to finish up the presentation here so that I can make sure that the people that came to hear it gets to hear it, because this is really, really important. So what we do is we'll use the lawsuit that you want to file in federal court to file as your answer, but you want to file them a file stamp copy of it, because once you do that, state court don't have jurisdiction to do anything anymore as long as your shit is pending in federal court. So, and attorneys won't tell you that either, okay, because higher court has jurisdiction. So therefore, the defendants can, instead of answering right away, they can raise one or more Rule 12b defenses, and only if the defendants lose that motion will they have to answer to the complaint. So that's what we do. You need to stall them off, and then make them spend some money answering to your stuff in your case. Okay. So one of the defenses in Rule 12b allows to be raised by motion is the defense that's set out in Rule 12b-6, failure to state a claim upon relief can be granted. Now, if the defendants win, the case will be dismissed. If they win their motion, the case will be dismissed, and then you'll have to appeal if you want to get your case reinstated. And when you do an appeal, you're going to have to appeal some kind of issue that happened in the case, because when you do appeal, you can't bring up anything that you didn't actually talk about or basically object to in the state case. Okay, so before we get into all of that, I want to take the time to tell you guys to make sure that you subscribe to my channel and click the bell, so when class starts, you ain't late, because if you're late, you're going to be on the line running. Okay, I haven't made anybody run yet, but I always thought about making somebody run. So, okay, let's stay focused. So in order to defend your property against a motion to dismiss for failure to state a claim under Rule 12b, we need to understand what a claim is under the rules of civil procedure. And I kind of put this off. I've been using because you'll see when we get into these rules that you don't have to have all of this stuff in line like we're going to do if you have enough facts in your claim to make the judge see that these other people don't want to come to the table. And the facts that we have are stuff they don't want to talk about, so they don't want to come to the table. So it's been working out, but there's been a few people that hit this little thing on failure to state a claim for relief, and the judge and attorneys are working together. So we're going to figure out how to do this and do it the way they like to have to do it. Then we're going to stick it right back in their face. So let's get started. And what you're going to find out, what I found out was, this is pretty damn easy. This is a lot easier than the shit I've been doing. So we're finna do this. So what is a claim? Under the federal rules of civil procedure, we have to understand what a claim is. So a claim for relief is defined in Rule 8A as having 3 elements. A are a short and plain statement of the grounds that provide jurisdiction to the court. Now, that's something that has to be in every claim. You have to have a jurisdictional statement or whatever. And we've had a couple of people, a couple of times federal court tried to throw people out saying they didn't have jurisdiction. Well, they do when you're going in for $5.5 million. They do when you're claiming a constitutional right violation. They do when they do. But they always say all this crap because people believe them. So when they come at you with that crap, when the federal court's trying to kick you out and say they don't have jurisdiction over state court, what you need to tell them is State court don't have jurisdiction to hear this case because the case was filed by foreign agents. A foreign agent must file their lawsuit in federal court. That would be like someone from another country suing you in state court. No, that's not the way it goes. As a matter of fact, if you sue someone in another state, you have to take them in federal court. And if they try to tell you, no, that's not true, then ask them, why is it the attorney had to file a notice of appearance? The attorneys have to file a notice of appearance because they're considered a foreign agent. You could even move to strike the attorney's notice of appearance because he's a foreign agent. And because they should have filed in federal court instead of state court. So that's how you make sure that federal court don't throw you out for a lack of jurisdiction. Okay, because state court don't have jurisdiction because it should have been filed in federal court in the first damn place. All of the real estate laws, they're all federal. So why is it they're filing this stuff in state court? Because it's fraud. Now, the second thing that you have to have, the first thing is you have to have that short and plain statement of the grounds that provide jurisdiction to the court. The second thing you have to have is a short and plain statement of the claim showing that the pleader is entitled to relief. And 3, the demand for judgment for the relief that the pleader seeks. Sounds like, what the hell? That's pretty damn easy. Now, for the B, the statement and the short and plain statement of the claim showing the pleader is entitled to relief. Well, the only thing that I want to talk about here is the stuff that's in the jurisdictional challenge with an affidavit. That is the only thing that I would ever want to talk about in foreclosure court or in any documents. I want to address the fact that the foreclosure statute that the court used to take jurisdiction is not a valid law. It's not a valid law because it does not contain the 3 elements mandated by the state constitution to be considered a valid law. The state constitution mandates that there must be a title, there must be a body, and there must be an enacting clause. Now, the enacting clause is really where I should have started because that's the most important thing. The enacting clause tells people from what authority the law comes from and who's subject to following it. We, the people of the Constitution, is the enacting clause of the Constitution. Now, your state constitution mandates all laws are to be enacted. And I'll tell you right now, revised codes and statutes do not have the necessary elements to be considered a valid law. So that revised code, the revised code or statute that they're using to do the foreclosure with against your property is a violation of your constitutional rights because it does not contain the 3 elements necessary to be considered a valid law. And I've been telling people this, and I don't think anybody's freaking used it yet. I don't think anybody's. That one thing alone can get your case dismissed because the court does not have jurisdiction if the law is not valid. And the law is not valid if it does not have the necessary elements that the Supreme Court says the law is supposed to have. So that's a wrap. I would use that. The other thing that I would want to talk about is the 6 missing things. Okay, you're in that jurisdictional challenge. You're claiming there are 6 things missing from the original contract, that are not on the contract that they filed in court right now for this case. And those 6 things that you're saying is missing is a problem. So one of those 6 things that you're saying is missing is you're saying that the bank agreed to do the deal according to GAAP, accounting principles, which are the federal banking laws. So you're saying that the original contract has a provision in it where the bank agreed to do everything according to GAAP. Well, you know what? The bank was supposed to do everything according to GAAP, and it didn't. So they're screwed. If they say they did do everything according to GAAP, they're screwed because it didn't. If they say they didn't do everything according to God, they're screwed because they were supposed to, and now they violated federal law. And there's one other thing that I can remember off the top of my head of the 6 things that we're asking for in the jurisdictional sound with an affidavit, and that is you claiming that in the original contract, the bank agreed to repay you the money for the alleged loan, the promissory note. The promissory note, the electronic credits for the promissory note was generated with your signature, and the bank agreed to give you that money, but they didn't. And then there's a few other things in there that are all similar to this, and they can't respond to it. They're having a lot of trouble responding to it, and that's why it's so badass. But anyway, those are the things that I want to talk about in your short, plain statement. Or if you got invested in one of the lawsuit packages, then you want to open it up and pick out the most important things in there. One of them is, I think on page 17, we're asking for the bank's accounting records that will verify that the loan was always an asset and never a liability. And not very many people know exactly what those records are or how to request them. And we're not really requesting them. We're just letting them know that we know about them, and those are what will prove the true nature of the loan. So the attorneys are going to know that you're going to demand that stuff in discovery if it gets that far. If it gets that far. And then C, the demand for judgment for relief of what the pleader is seeking. So that's not too, most people are going to have that in there because you want to make sure you know, you want them to know what you're asking for. So what this means is that the complaint must contain statements that support the federal court's jurisdiction. For example, in the case brought to enforce constitutional rights under 42 U.S.C. 1983, allegations of fact that support each claim must be made, and the request for relief. So the policy behind these rules is to simplify the pleadings and not to put up technical barriers to relief. And that kind of makes sense. Can't believe I'm saying anything that they do makes sense, but you got to understand this is what the rules we're all supposed to be following in court, including the attorneys. So the most important part of Rule 8A for the purpose of a Rule 6B motion is the second part, the short and plain statement of the claim. This is what we usually leave out. And I say we because this short and plain statement is not in my document either yet. But next week, I'm going to be changing some things and add these things to it, because all that's going to do is just blow it up right in their face. So this means that a short, plain statement of fact that make up the claim. For example, you must put in statements that show what happened to you, that you were seriously injured, and the mental state behind the mental state element required by the court, that the defendants acted with deliberate indifference to the Constitution or the law. Now, that I have in one of my lawsuit packages, but not in the foreclosure package. So we'll be adding that as well. If you fail to state deliberate indifference in your claim, it will be dismissed for failure to state a constitutional claim. And that's huge. And that's one of the things that most people aren't aware of. So you must make sure to make specific allegations of facts. Who did what, when, and where, to avoid conclusions. Also, be sure to include how you were injured by what the defendant did. After putting in the factual allegations, you can then say something like, these facts show the defendants violated the plaintiff's constitutional rights, and and violated the real estate deed laws or something to that effect. If you've included in your complaint the jurisdictional allegation, the facts of what happened, did the allegations of deliberate indifference and or necessary mental states and requests for relief, monetary damages or injunctive relief, then you have stated a claim. Now, the standards for Rule 12.6b motions, courts do not generally favor Rule 612b motions to dismiss because the policy of federal rules is to allow the cases to proceed if the plaintiff has a reasonable chance of obtaining relief. Now, what they also do is if you bring something to the table they don't want to deal with, they'll try to dismiss it like this too, because they know that you're not going to go and look up these rules and change your claim to fit their criteria, which you will be able to do after today. So the defendants are required to make a strong showing before a complaint will be dismissed for failure to state a claim. And that's when we roll by the rules in the real world. I'm not sure where that's at, but because that's not what they're doing right now. But we're going to make this a lot more complicated for them by putting their stuff in there that they want us to have. And then we'll see what excuse they come up with then. So a Rule 12b-6 motion argues that based only on what is said in the complaint, the plaintiff could not possibly be entitled to relief. Courts do not determine whether the facts as stated by the plaintiff are true, but instead assume the truth of the plaintiff's factual statements and decide whether you may have a claim that could lead to relief. As the U.S. Supreme Court stated, the issue is not whether the plaintiff will ultimately prevail, but whether the claimant is entitled to offer evidence in support of his claim. Now, I'm going to post this probably tomorrow, and maybe I'll get it done tonight. It's only 10:30. I'm going to post these case laws and everything that I'm reviewing here in the comment section so that you guys will have access to it, and you can copy and paste it or whatever and put it in your file so that when you're working on your document, you can open this up and use it as a guide to follow this, to make sure that you're doing the best job of putting yourself in a position that you need to be in. Okay, so a complaint should not be dismissed for failure to state a claim unless it appears beyond a doubt that the plaintiff can prove no set of facts in support of his claim, which would entitle him to relief. Clooney versus Gibson. Dismissal without leave to amend is improper unless it is clear upon de novo review that the complaint could not have been saved by an amendment. Snyder versus California DLC. So some important points to consider. And this is very important. The Rule 12b motion should not include any additional material by the defendants. Now, this is important. If the defendants attempt to add facts, it is likely that the motion will be treated as a Rule 12b motion. Okay, so it's likely that the motion will not be treated as a Rule 12b motion, but as a motion for summary judgment. And they use this to trick and throw people under the bus in court, because you show up to argue the wrong shit and you don't realize that they changed it in the middle of the stream. So you go ahead and you argue the Rule 12b instead of the motion for summary judgment, which is under Rule 56. And if this happens to you, what you do is you let the judge know that you need additional time to respond to their motion for summary judgment, because you showed up on their motion for a Rule 12b for failure to state a claim. and they switched it by adding additional stuff. So this means that deciding a Rule 12B motion against a pro se plaintiff, the court is supposed to look even more carefully to see whether any set of facts consistent with the complaint could be proven. And this is how our stuff gets in, because we do this very well. And if so, they're not supposed to deny on the Rule 12B. But the most important thing is to remember how they can throw you under the bus by adding things to it and changing that motion while you're in open court, or changing it into a motion for summary judgment without which you're not even knowing it. And now we're talking a whole different rules, a whole different response, and a whole different strategy. So when a Rule 12B6 motion becomes a motion for summary judgment, hang on a second here. So when a Rule 12B motion becomes a motion for summary judgment, and states matters in the pleading that are not present in the court documents, the motion shall be treated as one for a summary judgment. So the motion for summary judgment is governed under Rule 56 of the Federal Rules of Civil Procedure, and you will be allowed to comply to the Rule 56 if you ask for it. If you don't ask for it, they're just going to ignore it and mow you over. Therefore, the defendant includes the factual material along with a Rule 12B6 motion. You must object and demand the court to allow you additional time to respond. So that's the presentation for tonight. And you guys can see that this is not very complicated. You know, you got to kind of get it organized and make sure you put the heart of what you're throwing on the table in these three things that you got to have, and then you're ready to stick it in their face. Okay, so MX Apple, now it's time for all good men. Shit's coming down. Yeah, when you know the code. Yeah, well, the code's not, you know, the code and ordinances are not laws. They are. It's funny. People tell me, "Oh, you're practicing the unarmed practice law without a license." There's nothing that they're doing has anything to do with the law. It's about public policy. Remember, I already told you they're using revised codes and statutes. They're not laws. I think in 1933 or sometime when they switched gold and silver and screwed us all with these Federal Reserve notes, they removed the statutes at large, which was where our laws were found that protected us under the Constitution. They removed all of that shit and replaced it with their revised codes and statutes. And their policies. They're not laws. Okay, I'm just looking over. Okay, guys. So you guys know how to contact me. If you like to be in my Facebook page, then you can send me an email or a message. And if you send me an email, you can tell me you want to be in the page, and I can just copy your email and paste it in the page. And then you'll get invitation to join the group. You have to answer the questions. And if you're, hopefully, I try to make sure that everybody in the page is either facing foreclosure or fighting to block their illegal property tax collections. So I'm in the process of making a new Facebook page for the online course students. So the online course students are only talking about their stuff, and the other page is talking about the things that those people do in the group. And I think that's going to be a lot better for us. So that's what we're in the process of doing. So if you want to talk to me about your case, you can find me online and email me, or you can join my group and talk to me in a group. I don't really like to take a bunch of phone calls until people have already purchased their package and decided what they're going to do. And if you have questions, you can answer them. You can ask them in the group or ask them on the email, and I'll be glad to answer them for you. The time is now for all that men. I'm telling you right now, the time is now. That's the MYX capital. You couldn't have said that better. The time is now, and I'll tell you why. So I have people. I help people all over the United States, from California all the way to New York, and the other way too. And so people were telling me during the lockdown. So I work from home all the time. So I was still kicking it and getting stuff done. I have people telling me all the time that the title company, the court, all of them places will still have attorneys going in and out of them, just like they usually do. The attorneys wasn't staying home. And you know what they were doing is lining everything up so that when this moratorium ends, they can go ahead and bum rush everybody through. And I think what they're going to do is all the people that are sitting around now dragging their feet because the moratorium stopped everything, and so they're just stopped. They're going to be screwed when it starts. Because if I was the attorney taking your shit, I would be saying, hey, the moratorium stopped me from taking your shit. It didn't stop the court process. It didn't stop you from filing. You could have mailed your stuff in or sent it in by carrier or by aircraft bomber or something. Yeah, okay, the aircraft, I got a little carried away on the aircraft bomber. But that's going to be the deal. And they're not going to give you a break in eviction court. They're going to say you're getting jammed up and you had an opportunity to file stuff in your case and you didn't file shit and your time's up. So we're sorry. And judge, go ahead and give me the 10 days. You got the 10 days to pack your shit. And we'll see if that happens. I think that's the way it's going down. Yeah, other people feel the same way. Okay, guys, I'm going to get out of here and go snack on something because all this talk about kicking attorneys' asses is making me hungry. So, and I'll be back Saturday night. I'm not sure what I'm going to talk about, but I'll be here talking about something because I got a lot to say. Good night, guys. Good luck. And let's kick some attorney ass.